Welcome to the 𝗙𝗂𝗿 Elder Law channel. I'm your host, Melissa O'Connor. Today we're going to discuss Florida probate, specifically probating the formal administration. Chapter 733 of the Florida statutes governs the probate of formal administration, and in general, a formal administration is required when the decedent has been dead for 2 years or less, and when the value of the probate estate exceeds $75,000. Remember that the value of the probate estate is not the same as the gross value of the estate. A decedent's gross estate is everything that the decedent owned, no matter the nature of the ownership, whereas probate assets are only those assets that are owned by the decedent in the decedent's name alone. For example, if there is a listed beneficiary's name for a bank account, that would not be a probate asset. And if assets are held in a revocable or living trust, those do not pass through probate either. So even though the gross estate may be large, the probate estate may be small, and it may not require a formal administration. However, if the value of the probate, the assets exceed $75,000 and the decedent has been dead for 2 years or less, a formal administration is necessary. And for the formal administration process, it involves the application of a fiduciary to be appointed as the personal representative. That person may have to post a bond to the court, or the court may require a restricted depository in lieu of the bond. A restricted depository is just a bank account that no withdrawals can be made from without court order. Both the bond and the restricted depository are intended to protect beneficiaries should there be misadministration, whether accidental or intentional. The duties of the personal representative is set forth in Florida statutes, and they can be represented by an attorney to help them through that process. Creditors must be notified, and assets must be marshaled, and once the time frames for the creditor period and notices have passed, then the assets could be distributed, whether payments made to creditors, and then money is distributed to the heirs, either pursuant to the will that may exist or pursuant to statute. And then the personal representative would be discharged from any further duties and obligations, and the probate process would then close. A formal administration probate process in Florida and South Florida, where I practice, can take anywhere from 4 to 6 months, or many years should there be litigation involved and people not agree as to the way that the assets are designated to be distributed under the will. Should you have any questions or concerns, I encourage you to reach out to a Florida probate attorney. If this content has been valuable to you, I ask that you like and that you share with others that you think might benefit from it. Thank you and have a great day.